Quick disclaimer, this is an AI voice, which is not going to be perfect. There is a transcript in the description as well as subtitles for you to read along with. There are 3 offences against property, including theft, robbery, and burglary. A person is guilty of theft if he dishonestly appropriates property belonging to another with the intention of permanently depriving the other of it, as stated by Section 1 of the Theft Act. Appropriation means to take something, with Section 2 of the Theft Act stating that there must be a clear point in time when the appropriation takes place, which should link to when the mens rea is formed. This was shown in the case of Pitham and Hale. Property includes money and all other property, real or personal, including things and other intangible property, as stated in Section 4 of the Theft Act. This is shown in the case of Kelly v. Lindsay. Property shall be considered as belonging to any person having possession or control of it, or having in it any right or interest. This is shown in the case of R.V. Turner. This must be done dishonestly, which is not defined by the Theft Act. However, there are 3 subjective tests to help prove this. The first subjective test is that the defendant believed that they had a right in law to take the property, as shown in the case of Robinson. The second subjective test is that the defendant believed that they had the owner's consent to take the property. The third subjective test is that the defendant cannot discover the owner of the property by taking reasonable steps, as shown in the case of Small. The defendant must also have the intention to permanently deprive. If the defendant destroys someone else's property, then this is intention to permanently deprive the owner of its use or value. If the defendant offers the property for a price, this is theft, as the defendant is treating the property as their own, as shown in the case of Robbery. Robbery is defined by Section 8 of the Theft Act as a person stealing, and immediately before or at the time of doing so, and in order to do so he uses force on any person, or seeks to put someone in fear of being then, and they're subjected to force. In order for there to be a robbery, there must be a completed theft with the intention to steal, which is the dishonest appropriation of property belonging to another person with the intent to permanently deprive, as described in Section 1 of the Theft Act. This is shown in the case of R.V. Robinson. For there to be a robbery, the defendant must use force, which could either be a battery or an assault. This is shown in Corcoran v. Anderton. This force must be used during the theft or immediately before the theft takes place. This is shown in R.V. Vinor. The force can include the slightest touching or force applied to an object that the victim is in control of. This is shown in R.V. Clarden. The threat of force is also sufficient for a robbery, as shown in R.E.D. In order for there to be a robbery, the force used or the threat of force must be used with the intent to use this force to steal. This is shown in R.V. Bentham. The force or the threat of force does not need to be used on the person that the property was stolen from, as shown in Smith v. Desmond. If the defendant pulls or snatches the property without making contact, then this does not constitute force and is therefore not a robbery, as shown in P v. DPP. If the defendant uses force after they have completed the theft, then this is not considered a robbery, as the force is not used in order to steal the property, as shown in R.V. Lockett. Burglary is defined under Section 9 of the Theft Act 1968. It involves entering a building or part of a building as a trespasser with the intent to commit certain crimes. Entry is not defined in the Theft Act but has been interpreted by the courts. The entry does not need to be substantial, but it must be effective, as shown in R.V. Brown. Entry can also include being partially inside a building, as shown in R.V. Ryan. The building includes not only houses, but also structures like vehicles or vessels used as living spaces. A building can be any structure that is intended to be permanent, as shown in Stevens v. Geld. A vehicle cannot be considered a building if it has wheels, even if it is used for storage, as shown in Seekings v. Good. The defendant must enter without permission or legal authority, as shown in R.V. Collins. If permission is exceeded, they become a trespasser, as seen in R.V. Jones and Smith. For burglary, the defendant must have the intention to steal, inflict damage, or cause criminal damage. Under Section 9, 1a, the intent must exist before entry, while under Section 9, 1b, the intent can form after entry. Attorney General's references 1 and 2 of 1979 clarified that conditional intent to steal is sufficient under Section 9, 1a. Thank you for watching this video on Offences Against Property. I'll see you in the next lesson.